Good morning, Mr. Berman. Which matter are you here on?
I'm sorry. Talking to me, Judge?
Yes. Which matter are you here on?
Josephine Blue, but I believe the attorney for that is Joseph Yang.
He's here in the courtroom.
Oh, okay.
Okay, Joseph. This one's a 21-day waiver. Is that correct? Oh. Ms. Blue, can you hear me? I can't hear you. Can you speak up? We can't hear anything in the courtroom?
Yes.
Okay, thank you. We're on the record in the matter of the people of the state of Michigan, excuse me, versus Josephine Blue. File number is 22-506FY. Council appearance, please.
Thank you, Your Honor. Randall Berman on behalf of the people.
Good morning, Your Honor. Joseph Yang on behalf of Ms. Blue, who is present via Zoom. We consent to that portion of the hearing via Zoom.
Thank you. And today is the date that was set for a preliminary examination. My understanding, however, is that there is a request for a 30-day adjournment, and therefore Ms. Blue would need to wait for 21 days to examination. Is that correct?
That's correct, Your Honor. There's some discovery issues that Mr. Berman and I still need to discuss. So we will need, I think, 30 days. If we can do it sooner than that, we'll contact the court. But I think 30 days should be sufficient.
Okay, very good. Okay, and Ms. Blue, you understand that you have the right to have your preliminary examination here in the district court within 21 days of your arraignment?
Yes.
Okay, you understand that due to some outstanding or some ongoing discovery issues between your attorney and the prosecutor, you're not able to have that examination right now?
Yes.
Are you willing to waive the 21-day timeline for us to set it for a new date?
Yes.
Is anybody forcing you to waive the 21 days, ma'am?
No.
Okay. Did anybody promise you anything if you waive your 21 days?
No.
Okay. June 24th at 9 o'clock in the morning. Does that work for you both?
That works for me, Your Honor.
Yes.
Well, I was actually asking the prosecutor if it works for
Oh.
them.
Sorry.
I'm fine, Judge. Thank you.
Okay, thank you. Any additional matters for the record?
Not on behalf of the people, Your Honor. Thank you.
Nothing on behalf of the defendant, Your Honor. Thank you.
Thank you. You're all set. We'll see you on June 24th.
Thank you.
Thank you.
You can log off now, Josephine.
Adams is not here. Is that what's going on?
Yeah, so I guess Abbott said, first he thought Eaton County, but then he came and looked something up and said Clinton County, so we have to schedule.
Yeah, she's, sorry, I couldn't hear you, Eddie, but as far as time where she's supposed to be locked up in. Different county.
Okay, she's already waited for 21 days, so we'll reset that. Someone just joined from an iPhone.
Yes.
Start your video, please.
Okay.
What's your name, sir?
Jacob Blue.
Sorry, can you repeat it?
Jacob Blue.
Did you have a court date today?
No. I was
Okay,
on here with Josephine.
Okay, so unless you're a defendant or an attorney, you're not to log into the virtual courtroom
Okay, I'm
unless
sorry.
you were called as a witness to something and you were given permission to be here via the virtual courtroom. If you were calling to watch a proceeding, or you needed to watch a proceeding, you need to do it via Zoom, or you can come into the courtroom. We're open to the, via YouTube, or you can come into the courtroom, we're open to the public. And as for Ms. Blue, her matter will not be proceeding today.
Oh, okay. I'm sorry.
Oh, no problem. Thank you. Mr. Ferguson, which matter are you on? Is it Bastion?
Yeah, I have several matters, Your Honor, but the one that I'm on Zoom for is Mr. Peebles for a sentencing.
Okay. Is he in custody?
Yes, Your Honor.
Okay, we'll see if they can put him on or have him brought up if he's here. What's going on with Bastion?
I'm still waiting for him to arrive, Your Honor.
Okay. Well, we won't be waiting much longer because he's over 25 minutes late.
All right.
Okay. And then bond is not until 9. Mr. Carter was here for Naka Boylan.
Yeah.
Do we know if Ms. Boylan is here?
I'm not sure. That's a special assigned custody.
Yeah, Mr. Boyle's involved.
Yeah.
Judge, I'm gonna come into the courtroom.
Thank you. Okay.
Mr. Peebles,
Oh, Mr. Peoples says he's in custody.
he's on the polycom list.
Oh, okay. Well, they've been doing that this week.
Right, I just don't know how long. Or you do like or something like that, where you have.
Good morning, what's your name, sir?
Bush people. Let's look at it. See if we can do it. Ideally, you want all of that.
I wonder what other things are missing on other files.
I couldn't hear you.
You want me to log out in Zoom or just do it from the program?
You can go from here.
Okay, perfect.
Let me see if there's nothing really cut out.
Okay, well, we'll be just in time for a bench one. Okay, Mr. Peoples, your attorney is here in the courtroom. We're on the record in the matter of the people of the state of Michigan versus Louise Devon Peoples. File number is 20-00536. Counsel appearance, please.
Yes, Your Honor. Good morning, Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Peoples.
Today's the date that was set for sentencing. I do have a pre-sentence report and recommendation. Did you get a copy of that?
I did, Your Honor. I've had a chance to go over that with Mr. Peoples yesterday. We had no corrections to the body of the report. The only issue we had with it was with regard to the jail credit. They gave me 59 days as of April 18th. He's still been in custody through today, which would be an additional 24 days credit, Your Honor, to make it the 83 days.
Okay, sounds good. Do you have any allocation at this time?
I did, Your Honor. The recommendation is for 270 days in jail with credit for the 83 days in jail, or 59 at the time of the report, Your Honor. We would ask, instead of giving 270 days, we'd ask him to give him the credit for the 83 days and no additional jail time at all, Your Honor. He's done 83 days on this. The issue here from reading the pre-sentence investigation is doesn't seem to think he has an issue with substance abuse. The writer of the report may disagree with that, but if he's saying he doesn't have a problem putting him on probation, it's going to be not a good endeavor, and they're not recommending probation. So given all that, Your Honor, I just asked for 83 days for credit for 83 days. Thank you.
Oh, Court's had an opportunity to review the pre-sentence report. A rather lengthy history. We have before us a defendant who's pled guilty to one count of use of a controlled substance. Also is a concern that he obviously has a substance abuse issue, whether he believes he has a problem or not. But there also appears to be some concern about his mental health. And that may or may not be why he doesn't believe he has a problem. The problem is evident. What could be implied by the nature of the charge. He's using cocaine. He's had multiple convictions of this similar activity. And he's trafficking in and out of the jail system. And so if there's an opportunity to have that addressed or to give him some treatment and care to have that addressed, I didn't see any indication that he's tried that or that he's been through the CATS program or some of the programming and that it didn't work. Just that he doesn't believe he has a problem. So just give him credit for the 83 days. It's not in the best interest of Mr. Peebles. It's not in the best interest of the public either. Mr. Peebles needs to address the issue, and if it's going to take him some treatment before he can recognize he has an issue, then let's do that. So Want to adopt the recommendation of probation department. He is going to be sentenced to a term of jail time. We'll sentence him. 270 days with credit for 83 days, was it, or was it 84?
83, Your Honor.
With credit for 83 days, then I will order that he be screened and refer to Pat's for screening program while he's in custody of the jail. Mr. Peoples, do you have any questions right now?
No,
I can't hear you.
no.
Oh. Okay, so hopefully you'll get some help, sir, 'cause I think you need some, and I think although you may not be at a place where you understand or can admit that you have an issue, both myself and the people that did an intake on you or screening on you believe you have an issue, and so you need to get some help, sir.
It ain't no NAAA program.
Well, I'm not gonna order you to do that. You're not a good candidate for probation. And that's based on your past history, sir. So I think this is the only option that I have at this point to try to get you some help. Okay? Any additional matters for the record?
No, Your Honor, thank you.
Okay, an appeal of my sentence can be taken within 21 days to the circuit court. You're all set, sir.
Thank you, Judge. I'll see you in a little bit.
Thank you. You're all set, Mr. Peoples. Mr. Peoples, you can let the deputy know you're done.
So what was it? What was the agreement?
What agreement?
Oh, this ain't sentencing?
This is sentencing, but we don't have an agreement. You're gonna serve 270 days in the jail, and I'm referring you to the CATS program. I'm giving you credit for 84 days already served.
Oh, so I got 200 and so you said I got 287 days to serve?
No, I sentenced you to 270 days, but I gave you credit for 84.
All right.
Okay, you ready? On your matter? Yes. Naka Boylan. You're on the record in the matter of the people of the state of Michigan versus Naka Boylan, file number is 21-01006 FY. Council appearance.
Good morning, Your Honor. Natalie Maycomber on behalf of the people.
May it please the court, David P. Carter Jr. on behalf of Mr. Bailey. Sitting at council.
Today was the date that was set for a preliminary examination. Are we ready to proceed?
Yes, Your Honor.
Yes, sir.
Okay, any preliminary matters?
Your Honor, the only preliminary matter that people have is we do have 13 pre-marked exhibits that I believe will be stipulated to. All 13 are photographs.
Okay. Any additional preliminary matters?
I'd ask, I don't know how many witnesses the prosecutor intends to call, but I'd ask for a question.
How many witnesses are you calling?
Just 1 minute.
Okay, one witness. Okay, you can proceed.
Thank you. You'll call Officer Catherine Jablonski.
Swear or affirm that the testimony you're going to give is true to the best of your knowledge, information, or belief.
Thank you.
You can have a seat here. Please state your first and last name and spell them both.
Catherine Jablonski, KATHRYN, JOBLONSKI.
Thank you. Officer Jablonski, where are you employed?
Ingham County Animal Control,
And how long have you been with the Ingham County Animal Control?
3 years.
What is your current assignment with Ingham County Animal Control?
I'm an animal control officer.
And what does that mean?
That means I enforce state laws and local ordinances pertaining to animals while protecting the public and the animals within the county.
Did you hold that position back in February of 2021?
Yes,
Were you working on the date of February 17th, 2021?
yes,
During your shift, did you have a reason to respond to a 922 North Martin Luther King Boulevard in the city of Lansing?
Yes.
Then Ingham County, Michigan?
yes.
What was the purpose of your response to that address?
That response was to check on dog licensing and the welfare of animals.
And what made you aware that there may be an issue there?
I was assisting Officer O'Neill on the case.
And when you arrived at 922 North Martin Luther King, did you make contact with any persons there?
Yes.
Who did you make contact with?
That day we made contact with Donald Bailey.
And were you able to determine who Donald Bailey was?
He was one of the animal owners in the home.
Did he live at that residence as well?
Yes.
On that date, were you able to see any of the animals that you had concerns about?
Yes.
How many animals were you able to see?
10 dogs approximately.
And when you were viewing those animals, was there anything of concern?
A concern for some of the animals have some skin issues, missing fur, red skin.
In your conversations with Mr. Bailey and in your investigation leading up to that, were you able to determine if Mr. Bailey owned all 10 animals?
No, he did not own all 10.
You know how many he did own?
6.
That would be 4 remaining animals?
Correct.
Were you able to determine who owned those 4 animals?
He said they belong to.
Objection, Your Honor, hearsay.
And I'd ask that it be admitted just to inform that the officer did not, and not necessarily for the truth of the matter.
It's not being offered for the truth of the matter asserted.
I'm sorry.
She said it's not being offered for the truth of the
Well,
matter
it most
asserted.
certainly is, because it's gonna go towards the owner of the dog. That's just she's just trying to get around the hearsay rule. That's the only way she's gonna link it to my client ownership of the dog, what this individual says. So she can try to say that she's using it for other purposes, but it isn't. It's gonna be towards the owner of the dog.
Your Honor, I guess it's an offer of proof to show there were 10 dogs seen on the 17th. Those dogs were not all seized on that date because they learned 4 dogs were not owned by Mr. Bailey. They returned 2 days later to execute a search warrant where they made contact with the defendant in this case and were able to confirm with the defendant that the other 4 dogs are owned by the defendant and his wife.
So as Mr. Carter has indicated, the only link to the defendant as ownership.
I'm sorry.
Mr. Carter is arguing that although you're saying you're not offering this as towards the proof of the matter asserted, that this is the only link that you have to establish ownership.
No, Your Honor, I guess what I'm saying is that it informs why the officers did not impound those dogs that date, along with some other testimony that will come out. But then when they return 2 days later is when they actually are able to confirm ownership with the defendant himself.
So there was another interaction with you.
There
Your
was. Your Honor.
testimony was.
Yes,
Okay, the objection is overruled.
thank you. Your Honor. Were you able to determine who owned the other 4 dogs?
We were told Tammy Brown.
And you were able to speak with Tammy Brown?
No.
Now, when you were reviewing the animals, were you able to view the inside of the home?
Not at that time.
Why not?
They were not allowed us in the house.
When you were at the home that day, was there anything about the home itself that caused you concern from the outside?
There was buildup of personal material on the front porch. There was a window on the front door that you could see inside of the house. You could tell that there's personal belongings and hoarded tendencies inside of the home.
Speak up for me, please. I'm having,
Hoarded
two fans
tendencies
going.
inside of the home.
thank you.
You said that you could see personal belongings. Do you mean like clothing, furniture, or can you describe more what you mean by that?
Stuff, I mean, coolers, patio furniture. I don't exactly remember what was in all of the pile, just things that tend to own at home.
You said hoarding tendencies. What do you mean by that?
Stacked up in piles, not organized, kind of cluttered.
Now, after or on the 17th, did you seize those animals that day?
No,
What did you do?
we left the scene, and they came back with a search warrant.
And did you come back on February 19th, 2021?
Yes,
And were you part of that search warrant execution?
yes,
Who else was there that day that you can recall executing that search warrant
as an officer standpoint, or
from the officers?
Officer O'Neill, Officer Meisling, Deputy Director of the Holy Strait, from all departments.
And so Officer O'Neill is O'Neil.
Yes,
Officer Meisling is MEISLING.
yes,
And Deputy Director of the Hope Strait is VERHOUGSTRAETE.
yes,
And were there any civilians there that day?
yes.
Who was there that day?
Donald Bailey was there, Gwendolyn was there, I think it was Bailey, it was Don's wife, Tammy Brown was there, and Matt was there.
You said in NACA.
Yes,
Do you see NACA in the courtroom today?
yes.
Can you describe where he's sitting in an article of his clothing?
He is wearing a brown t-shirt next to the defense.
Can the record may reflect identification?
No objection for preliminary purposes.
Just, it is noted. Thank you.
Thank you. When you executed the search warrant on February 19th, 2021, what did you observe?
I observed, we took 10 dogs out of the house. They're being very cooperative and bringing one dog out at a time for us. That was part of the training of getting the dogs out of the house. After all the animals were removed, I went inside the house to observe the conditions and get, I believe, one final dog that wouldn't come out.
Now, speaking specifically to the 4 dogs that you had identified that were not, you had learned were not owned by Donald Bailey. Do you remember the names of those dogs?
I don't.
You saw a copy of the report with that help refresh your memory?
Yeah.
May I approach this? Have a couple, you're finished. Do I have fresh in memory?
Yeah.
Can you tell the court what the name of the 4 dogs were that were not owned by Donald Bailey?
Betty, Slippers, BJ, and
Pancho something?
Poncho, yes, thank you.
When you were seizing those 4 animals, were you able to determine who the owner of those 4 animals were on that day?
Yes.
And who did you speak with in order to do so?
Actually, let me retract that. I didn't do any of the speaking. I just took all of the animals out of the home and took photographs.
And were you there? Did you overhear any information from the defendant regarding the ownership of these animals?
The defendant said that they belonged to his wife.
And that did he live at that home as well?
That was presumed.
And what was the purpose of seizing the animals from the home?
The original purpose was unlicensed. An additional purpose, once we got in the home and saw the living conditions, it was unsanitary.
What do you mean by unsanitary?
The hoarding, clutteredness that we viewed on the front patio continued into the home. Very minimal space to move around. Personal belongings, trash piled up high in multiple areas. Cobwebs everywhere, soiled surfaces, uneasy to move around, mold, ceiling falling down, cabinets in the kitchen falling down.
Were you aware whether or not the housing commission was ever contacted in regards to this home?
Yes, they were.
Were you made aware through your investigation of whether or not any action was taken by the housing commission?
The house is red tagged.
On the day when you were seizing the animals, did you take photographs that day?
Yeah.
Did other officers take photographs that day while you were there?
Yeah.
Pardon me, I first witness. So I'm handing you people's exhibits 1 through 13. If you could go through those kind of one at a time and explain what each photograph depicts.
Exhibit 1 is standing just inside the front doorway, looking. You're in the living room area, looking back towards, I guess, what would be considered the dining room before you get to the kitchen around the corner. It's just cluttered with personal belongings. You can see the ceiling going down in the corner, cobwebs everywhere, things that could easily fall down on you. Exhibit 2 was in the living room. The one chair that could probably be sat on in the living room, besides the wheelchair that was in there. Cluttered and stacked personal belongings and trash. Exhibit 3, a lot of cobwebs, unfriendly, on top of stacked hoarding belongings. 4, this was going into the kitchen, stove on the right hand side, just the floor is cluttered with personal belongings and trash, unsafe to walk, and things just stacked up, personal belongings and more trash stacked up on. Exhibit 5, it's back from the living room looking into, I guess, the dining room before you get to the kitchen. Stacked supported belongings, there's only one trail to go from this room into the kitchen. This is where you can see the dog bowls where they keep. Exhibit 6 is where you see wild rats feeding off of the dog food inside the home. Exhibit 7 is a stairwell going up to the second level of the home. You're either moldy or unsanitary. Being kind of unsafe. Exhibit 8 is at the top of the stairs looking down to the first level. Cobwebs, drywall coming off the wall. Exhibit 9 is working up towards the second level on the stairwell. This is getting towards the top of the stairwell. The drywall on the ceiling has now been replaced with plastic. And there's mold, black mold, growing underneath that. Exhibit 10 is BJ on intake. Exhibit 11 shows BJ's skin condition that we were concerned about. Missing fur, skin's pretty red. Exhibit 12 kind of shows the same thing. Back behind you. Exhibit 13 shows more of his skin being irritated and red.
May I publish those to the court? And Officer Jablonski, while you were at the home, excuse me, did you notice any excess animal waste or urine throughout the home?
I didn't particularly notice piles of feces in the home. Just the floors were pretty soiled with what could have been old feces, dirt, uncleanliness, just accumulation of living in the home and that cleanliness.
You mentioned a couple times, excuse me, stacked objects.
Mhm.
Why did that pose a concern for you?
That's a huge concern of the objects falling down on the animals, objects falling down on the individuals in the home. It creates just uncleanliness, dust and dirt getting collected in there and causing unsanitary air. The animals climb on it, knock it down.
And you noted in the photographs of the dog named BJ that there was a skin condition you were concerned about. Did you notice while you were going through the home anything that would indicate that BJ was getting medical care for that skin condition?
No.
Any vet records or medicine at all?
No.
In the areas of the home that are depicted in those photographs, did all 10 dogs, specifically the 4 that were associated with Tammy and Naka, did those 4 dogs have access to those areas?
Yes,
Including a stairway in the upstairs?
yes.
And nothing further?
Cross-examination.
Thank you. I'm sorry if I butcher your name. I'm letting you know. I apologize ahead of time. Is it Officer Jablonski?
Yeah.
Officer Jablonski, my name is David Carter. I represent Mr. Boland in this matter. I'm going to ask you a series of questions. If there's a question you don't understand, just please let me know and I'll try to rephrase it. I only have a very few questions for you, not very tough ones. You indicated that you overheard a conversation, Mr. Boland telling somebody that they were his wife's dogs, correct?
Correct.
All right. And you also indicated that you presumed that Mr. Boland lived at the house, correct?
Correct.
You have no information that these couples were going through a divorce and that he had left out of the house several months prior to that, do you? Thank you. I have nothing to.
Redirect.
Officer Jablonski, Mr. Boland was at the home the day that you executed the search warrant.
Yes, he arrived shortly after we started.
And after he arrived, did he indicate to you in any way that he did not live there?
Not to my not to my knowledge, sorry.
And did he stay on the property while you were executing the search warrant?
Yes.
He did not leave?
No.
Minutes with the excuse?
Yes, sure.
Thank you. If the excuse, I'll take it once again. Any other witnesses or proofs that will be submitted by the people?
No, Your Honor. Correct.
Will the defense be calling?
No, you're.
Take argument.
Thank you, Your Honor. Your Honor, based on the observations of Officer Jablonski and the other officers that were there that day, there were the photographs, it's very clear that the home that these dogs were living in is not a sanitary home. In order for there to be adequate care, the statute says there has to be a sanitary living conditions, including a space free from excess hazard, excess animal waste or urine, and that is able to keep the animal in a good state of health. We have animals that have skin conditions that aren't being taken care of, but that are living in, with all due respect, in a filthy home where rats are openly eating out of the same bowls that these dogs are eating out of, where there's old feces on the floor, where you can't walk through the home without fear of things falling on you, when there's mold, the stairway is crippled, there's mold in the ceiling. It's very clear that this is an unsanitary condition, not only for the animals that were in the home, but also for the humans that were living in the home, which is further evidenced by the fact that the house ended up being red tagged by the housing commission. When we get to the heart of what the argument is going to be today is whether or not Mr. Boland is an owner of these animals or whether or not he would fall under the statute. The statute is very clear that it's anybody that has care or charge or custody over the animal. Mr. Carter asked a question about whether or not there was going to be a divorce. There's been no evidence that that's actually the case, whether or not Mr. Boland did not live there. He arrived at the home during the search warrant execution. He stayed during the pendency of the execution of that search warrant and never once identified to any officer that he may or may not live there. If he wasn't living there, if he was going to a divorce, if he wasn't staying at the home at the time, he would have no reason to stay there during the pendency of that search warrant execution. Based on the proof that were provided today, we ask you to so on the charge.
Well, thank you, Your Honor. We'd ask that not be found over. First of all, this would be the first time that I heard that somebody who exercises their right to remain silent and not tell officers about themselves, somehow they're automatically owners of dogs now. The only evidence we have here on this record is that the officer overheard my client tell somebody that they were his wife's dogs. That's the link, that they're married. Just because they're married doesn't mean that he's responsible for the dogs or that he has the care for these dogs. Matter of fact, there's no evidence whatsoever that him or his wife even lived there. To be honest with you, they just show up with a search warrant. There's no evidence of ownership of the dogs outside of my client indicating that these are his wife's dogs. as far as this presumption that he lived there, I don't think my client has a duty to reveal to anybody, oh, I live here, and just because he stuck around while they executed a search warrant on his wife's dogs, I think any spouse would do that. I just don't think that they've met their burden, and we'd ask the case to be dismissed.
Here's the date that was set for preliminary examination. Mr. Boylan, at the time of examination, the burden is on the prosecution to establish probable cause. Probable cause of the crime was committed and probable cause sufficient to charge you, the defendant, with the crime. And that burden is not the same burden that is placed on a trial. A trial, the burden is beyond a reasonable doubt. And that burden is still met or placed really on the prosecution. This is a burden that requires more than mere suspicion that a crime is committed. We have testimony today that Officer Joe Blonsky reported to a address of 922 North Martin Luther King Boulevard in the city of Lansing, Ingham County, state of Michigan, first on February 17, 2021, check on licensing of a dog or of dogs, I should say. She identified that there were, or she saw 10 dogs at the property on that date, and that she did not take any of them into custody at the time because the person that she spoke with at the time was not the owner of all the dogs. He would not allow her into the property at the time to search the property. So she returned 2 days later with a search warrant. At the time, those 10 dogs were still there. And during the execution of the search warrant, the defendant, Mr. Boylan, arrived to the property. Argument is that he stayed on the property, and officers presumed, Mr. Boylan was a resident of this property based on the circumstances. So we have circumstances where Mr. Boylan indicates that these are his wife's dogs. He arrives to the property, these dogs are twice. It's possible they may be going through it, worse, it's possible they're not. That's not evidence, that's before the court to consider. That's argument. So if that is in fact evidence, that's should go before a trier of fact. I can't make a determination on that. I think that there is sufficient probable cause for the purposes of your examination today to bind this matter over to the circuit court. So I will bind over, this matter will be bound over to the circuit court for a date of May 25th. You do not need to appear in court on that date. That's just the date that the circuit court's going to get the file from this court. We will not have arraignment in circuit court because unless Mr. Carter gives them a reason to hold another arraignment, that arraignment in circuit court will be waived. Okay, sir? Your next court date will be pre-trial in circuit court. Mr. Carter will be made aware of that date, okay?
Yes.
Bond was set at $500 personal recognizance, and that will continue. Any additional matters for the record?
No, Your Honor.
Nothing to do with that. Thank you.
You're all set.
Thank you. Pronunciation.
No, that was good. I was very impressed, actually.
Who want your exhibits, please? Okay, do we know if Mr. Bastian is here?
Thank you.
assuming LeBros wasn't here either.
No, I am not.
You know where, Mr. Bastian went?
He was one of the Mr. Knight.
Okay, we're on the record in the matters of the people of the state of Michigan versus Michonne James Jackson. File number 22-00726 FY. And the people of the state of Michigan versus Javon Anthony Jones, file number 22-00727. Council appearance.
Morning, Your Honor. Andrea Lacy, appearing on behalf of the people.
Morning, Your Honor. May it please the court, Assistant Public Defender Steve Cornish, for Mr. Jones, who's in the court and seated to my right.
Your Honor, Eric Tomal for Mr. Jackson.
Okay, today was the date that was set for preliminary examinations. Are we ready on both matters?
Yes.
Any preliminary matters?
There are some potential issues, Judge, with possible bond violation. But I did do my best to listen to jail calls from both defendants prior to starting this morning, and I do not have any jail calls that support that, but I'll have to bring that up.
Any additional preliminary matters?
Your Honor, my understanding is only one witness here today, so I don't think we need to sequester, but in case another witness appears, we'd ask for sequestration.
Sounds good.
Nothing.
Okay. I will grant the request for sequestration. Not sure that it's needed, but you can call your next witness.
Thank you, Your Honor. For the first witness, who will call this again, for Anthony Lavas, it's Lovaas.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury? Thank you. You can have a seat. Okay, Mr. Jamal, can you two switch? Needs to be on the inside. Thank you.
Just for the record, I got a big fan blowing. It's hard to hear from me.
Oh, we can stop the fan.
Okay.
It just come in before we start to restart the AC unit. He had stopped the vent, so they should kick in at some point. Okay. Please, sir, I'm gonna need you to state both your first and last name and spell them, but let me give you a couple of rules. I have a court recorder here, and as indicated, we have fans blowing. We need to be able to hear everything that you're stating because the court recorder behind you has to make a record of what's happening here today, okay?
Okay.
So all of your responses must be verbal, no head nods and shakes, because she can't write that down. Also, people have the common tendency to say, you can't write that down, you need yes and no, okay? If not, we'll always ask you, is that a yes or is that a no? If there's an objection, you'll stop whatever statement you're making. I'll make a ruling on the objection, then I'll give you a response as to whether or not you can proceed with your answer or not, okay? Okay,
Okay,
okay, please state your first and last name and spell them both.
Anthony Lovis, ANTHONY LOVAAS.
Thank you. You can proceed, counsel.
Thank you. Mr. Levis, I'm going to take you back to February 13th of 2022. Do you remember that date?
Yes, I do.
Okay, and did something happen on that date that brings you to court today?
Yes, I did.
And on that date, approximately around 12:50 or 1 a.m., were you present in the area of 1022 Hateman Street in the city of Lansing, county of Ingham?
Yes, I was.
Okay. And what's located at that address?
My house.
Okay. And I'm going to have you walk us through a little bit of what happened on that date. So what were you doing at around that time?
Sitting on the couch watching TV.
Okay. And was anyone present in your home?
No.
Okay. Was it just you?
Yes.
Okay. And what happened?
Sitting on the couch and walked in the door with these two guys.
Let me back up. You saying that they walked into your house?
Yes, I saw, what's his name? Javon walk in first. And there's a few other people following behind him. The only other person I knew was KJ. He put a gun in my head.
Okay, let me back you up real quick. So you've identified this individual over here as Javon, is that correct?
Yes.
And you said that he did enter your home?
Yes.
Okay, and can you just describe an article that he's wearing today for the court?
Today?
Yeah.
Gel blue jumpsuit.
Your Honor, please let the record reflect the witness has identified defendant Javon Jones.
Any objection to identification?
Not for prelim, Your Honor.
Identification is noted.
And then you indicated that this individual over here, you know as KJ, is that correct?
Correct.
Okay, and he also entered your home, correct? And can you describe an article that he's wearing for the court today?
Same blue, gel blue jumpsuit.
Yeah, Your Honor, please let the record reflect that the witness has also identified the defendant, Michelle Jackson.
Any objection?
May I vote?
You may.
Mr. Levis, you indicated that KG entered your house, correct?
Correct.
And the person who you identified as KJ, did that person wear a mask over his face?
Yes, he did.
What color was the mask?
Black.
And the mask itself, did it cover all the way up to the bottom of his eyes?
No, it did not.
Describe how the mask was covering his face.
Right here.
Below
Right
his,
under his nose.
then that's the top of the mask, correct?
Yes.
The
Correct.
bottom of the mask went below his chin?
Yes. Right.
Okay. Now, how do you know that was KJ?
He's been in my house numerous times. I've seen him pretty much once a week at minimum. I know it was KJ. I know who he is. I know his voice.
Okay, did the
100% positive.
Did the person, when he entered your house, who you identified as KJ, did that person speak to you?
Right away?
Yes.
Not right away.
Okay. That person who you identified as KJ, did that person have any distinguishable characteristics about his face?
Tattoos on his face.
Let the record reflect what was just looked at my client before he answered. What kind of tattoos do he have on his face?
I don't know. Tattoos on his face.
Okay. Anything else that's distinguishable about his face?
His eyes.
What about his eyes?
Color of his eyes, a little different, a little hazelish.
You mentioned his nose.
Yes.
What
I know
about
what his nose looks like, sir.
You know what his nose looks like?
Yes.
Is there
Like I said, I've
something,
seen him on a daily basis, almost a weekly basis at my house.
is there anything unique about his nose?
No. No.
Was that person who you identified as KJ, was he wearing a hat at all?
Yes.
What kind of hat?
It's one of these, I don't even know what you call it.
Do-rag, knit hat?
It's not a do-rag, it's like a one-piece little that goes around like this. He wore that all the time, every single time I seen him.
All right, you just made a motion, one piece, and you went from your eyebrows down to the side of your face with both fingers, correct?
Correct.
So is it more of a, I'm not sure the correct term, but more of a ski mask where only a ski mask kind of thing where everything's covered but his eyebrows, his eyes?
Not like that, sir.
Well, you did it.
I said like this, not like. This.
Okay, so
I get what you're getting.
well, I'm asking, you did a motion above your eyebrows, correct? Yes.
Is that a yes?
That's correct.
Then you motion to the side of your face with your fingers, correct?
Correct.
And the whole back of that portion was covered with this mask.
The whole back portion. Same.
Yes.
That's correct.
We just don't know the name of what you're describing, but it's some kind of a hat that covers the majority of his head and neck. True?
Correct.
So the only visible portion that you saw of who you identified as KJ was this person's, the bottom of his nose up to his eyebrows, correct? Yes.
Correct.
Everything else would have been covered on that person's face with the mask.
Correct.
Which would be two masks. A mask on the face and then this thing around his head, correct?
Yeah, correct.
Nothing further.
Okay, any objection to identification?
No objection.
Okay, identification is noted.
Thank you. Now, Mr. Kamal got into a couple of things that I was going to ask you as well. You had contact with both of these individuals previously, correct?
Correct.
And what's the nature of your relationship with them, if any?
Right.
Friend, okay, and you said they've been to your house,
Correct.
okay? How long have you known them?
I've known him about a year, KJ. Javon here maybe a few months.
Okay.
He brought him, came over with him
Okay, and they've both been inside your house before,
many times.
and you thought of them as friends prior to this incident, correct?
Right.
Now, you said that he had pointed a gun to you, is that correct? And that
Correct.
Mr. Jones? Correct?
Correct.
Okay. And where were you? Were you seated? Were you standing? What happened when they walked in
Sitting on
your
my
house?
couch,
Okay. And where was he when he pointed that gun at you?
right in front of me, put it to my forehead.
Okay. So I'm gonna have you walk us through a little bit. You said they entered the house through a door.
Correct.
Which door?
My dining room door.
Is that on the front of your house or the side of your house?
Depends on which way. I mean, it's used as my front door, but it's technically the side door.
Okay. And this would be the door that people normally come through, you said?
Correct.
Okay. And how far away from your couch is that door, if you know?
Roughly 15 feet.
Okay. So they come in the house, you said, it's Mr. Jones first, a couple of other guys you don't recognize, is that
Correct.
correct? And then KJ, correct?
Correct.
Okay. And Mr. Jones comes directly to you,
Correct.
and what does he do?
Walks up, puts a gun to my head, had my pockets out, so what I got for him, and I said I ain't got shit for him. And, KJ comes around the corner, dangling my keys. Said, well, we got his keys. And I started laughing at him, Javon, and he said, I got pissed off and laughing at him, and said he's gonna shoot my dog.
Let me back you up real quick.
Mhm.
What kind of, did you get a look at the gun that he was holding at the time?
Yes, I did.
What kind of gun was it? You know?
It was black, it was a silver top, studded clip.
Okay. And was it pointed directly at your head? Was it touching your head?
Yes.
Okay. And when he did that, were you scared?
Yes.
Okay. And then you said at some point he then threatened to kill your dog because you were laughing at him. Okay. And did that scare you as well?
That really did it.
Okay. And you indicated that KJ came around the corner and had keys. Could you
Sure.
see the keys that he had at that point?
Yes, I could.
Okay. And you recognized them?
Yes.
And they were your keys?
My keys, yes.
Did he have any other keys?
Yes, but I didn't recognize those ones so much. They weren't like.
Okay. And you said you heard him say that he had your keys. Is that correct?
Correct.
Okay. Did he say anything to you directly?
Just that.
Okay. And do you know if he had a gun as well?
Yes, he did.
Okay. Did you get a look at that gun?
It was a black one.
Okay.
No, it's all.
Okay. And he was approximately 15 feet away from you at this time?
Correct.
Okay. Did he get at any point, did he get closer to you?
No.
Okay. So he did have that gun.
Yes.
Were you scared seeing him with that gun as well?
Yes.
Okay. And the other individuals that were in your house, did they have guns?
Yes.
Okay. Were you able to get a look at their guns?
I didn't get a great look at them. They all look like regular black guys. So I don't really any specific details on them. Nothing.
Okay. But you did recognize them as guns?
Yeah.
And you thought they were real?
Yeah.
Okay. And did any of these people have permission to be at your house at the
No.
time? Okay. They have permission to have your keys?
No.
Okay. And what happened after Mr. Jones threatened to kill your dog?
After he came around, KJ came around the corner with the keys and said, "Let's go." They left.
Okay. And did they leave out that same door they came in?
Yes, they did.
Okay. And they had your keys at this time, correct?
Yes, they did.
Okay. And did you give them permission to take your keys?
No, I did not.
Okay. And what were those keys to?
My house, my truck, and actually had other keys to the other houses that I do property for and all that. So quite a few different keys to the houses, my truck, my house.
Okay. What kind of vehicle do you have?
A Suburban, black Suburban. That was the one that they took, was the black Suburban.
Okay. And you indicated they took it. So when they left out of the house, did all four of them leave at the same time?
Yes.
Okay. Did they say anything to you?
Don't move.
Okay. And did you move after they left?
After they left,
Okay. Did you see them get into your vehiil?
No, I accidentally looked like when I left. I didn't
Well,
look out
let me
until
back you up. What did you do after they left?
I sat there.
Okay. And then what did you do after that?
I got up and looked out the window.
Okay. And was your vehicle
Gone.
gone? And where had it been parked?
Right in the driveway.
Okay. And was that right next to the door?
Right up. Yeah, I mean, the door's here, the driveway's right here.
Okay, so in close proximity to that door, is that
Yeah,
correct?
yeah.
Okay. Did you hear your car leave
Yeah.
the residence? Okay, and you were not aware of anybody else being present outside your house or anything like that at the time?
I wasn't aware.
Okay, and nobody had permission to leave with your vehicle, is that correct?
Correct.
Okay, and what did you do after you realized that your car was missing?
Called the guy whose other vehicle was there.
Okay.
And he had because I knew he had a GPS tracker on it,
Okay,
and he found it right away.
okay,
And I'm talking to him on the phone the whole time. And when he found it,
you can't tell me what he said, so let me back you up real quick. I'm gonna parse it out a little bit. Who was the individual that you contacted? What's his name?
I don't remember his name. It was a friend of mine.
Okay,
Like, I don't really know him indirectly.
okay,
There was a friend that asked if I could use it. He was some parking part of it.
okay, and do you know if that car belonged to him?
Yes.
Okay, and he was parking in your driveway?
Yes.
Okay, and you contacted him, telling him his car was gone as well?
Yes.
Okay, and had the keys to that vehicle been inside your residence?
Yes, they're right on the, I had a bowl on my table, which one with my keys originally.
Okay. So they were with your keys at the time?
Yeah.
And were you familiar with the set of keys?
No.
Okay, so can you tell the court whether or not those keys that you saw Mr. Jackson or KJ with, were those the other keys that were in that bowl?
They were the only other keys in the bowl.
Oh, okay. No other keys?
No.
Okay. So those would be the only two keys they would have had access to for that bowl.
Right.
Okay, and that bowl is where?
Right on the dining room table, right in the middle.
Okay, and is that located in your house close to that back door in which they came in?
Right in front of it.
Okay. So you contacted him and he had GPS on that vehicle, is that correct? Okay, and he was able to locate that vehicle?
Right.
Okay, and you didn't go with him to
No.
go find the vehicle?
No.
Okay. What did you do after you talked to him about the vehicle?
Talked to the police.
Okay, so you called the police immediately after?
Well, he had called the police. And
Okay.
I talked to the police through him, and then they got my phone number and called me after that.
Okay, so you did talk to them?
Yeah.
Okay. And,
Then they came to my house as well.
okay. Now, when you talked to the police, you explained to them what happened, correct?
Correct.
And were you able to give them descriptions of both of the people that you knew?
Correct, yeah.
And did you also provide descriptions of the two people that you did not
Yes, something with what I could have.
know? Fair. And you also indicated the names of Mr. Jones and Mr. Jackson, is that correct?
Correct.
At least to the extent that you knew them? Give me 1 second, Your Honor, sorry. Now, when Mr. Jones approached you with the gun in hand and put it right up to your head, did you feel that he was trying to rob you?
Yes.
Okay, and did you think that the three other people there were there to help him do that? Okay. And you felt intimidated because there's four of them and one of you?
Yes.
Okay, and they all had guns, correct? At any time did Mr. Jones threaten to shoot you as well as your dog, or was it just your dog?
Just the dog.
Okay. Now, I'm going to talk about the dog just a little bit. You had talked to the police officers about your dog and the dog's reaction to them entering your home. Is that correct?
Right.
What's your dog's normal reaction to people entering your home when they don't know them?
Barking.
And did your dog bark in this instance?
Not at all.
Okay. So you hear somebody entering your home and your dog isn't barking. Are you concerned at that point?
If they bark?
If the dog was barking, had you?
Yeah.
Yes. Okay. But as soon as they entered and you saw them with guns, you were concerned, correct?
Right.
Okay. And your dog recognized them, at least
So
from what
that's
you can
what I'm
tell?
gonna say.
Okay. And you indicated that Mr. Jones actually went through your pockets, is that correct?
Right.
Okay.
They patted him down.
patted him down? Okay. Didn't find anything?
Well, I didn't put nothing out.
Now, that, with regards to that car that was being kept on your driveway, yeah, weird question, but I'm asking anyway. Did you have permission to give anybody else permission to drive that vehicle?
No,
It was just supposed to be stored there, is that
Yeah.
correct? Okay. And no one ever contacted you to say that somebody else was coming to take that vehicle, correct?
correct.
Okay. Now, officers responded to you, correct?
Right.
Was your vehicle ever recovered?
Yes, it was.
When was that?
Day or two before the last birthday I was supposed to be here for them.
Okay. Last court date was back in April, is that correct?
Yeah.
Okay. And this happened in February, correct?
Yes.
Between the February and the April date, did you know where your vehicle was?
No, I did.
And did anyone contact you about your vehicle?
No,
Okay. And then you said it showed up?
it showed up.
Okay.
Sitting in front of the neighbor's house. And I actually saw it there for about 2 days and I never even thought twice about it. I thought it was just like somebody visiting a neighbor. And finally I seen the side of it. It's not too many 4x4, Suburban, say 4x4 on it. And that's when I did a double look and realized the keys were in it. It's fine.
Okay.
No tools, none of the stuff was in it that was in it before, but
Okay. So let's talk about that real quick. So you said your vehicle was a 2001 black Suburban, is that correct?
Right.
Pretty common vehicle, correct?
correct.
So when you first saw it, you didn't think anything of it.
Correct.
And then you realized that it said something specific to your vehicle.
Correct.
And then you went over and did some investigation,
Mm-hmm.
noticed your keys.
Right.
And those keys obviously known to you, correct?
Well, it was just the key. It wasn't all of my keys.
Okay.
That were on it before. It was just the key to the truck and the key fob. The rest were gone.
Okay, so the key to your house and the key to any other properties that you were working on, all gone.
Gone.
Okay. And you said that there was other things of value in your vehicle, is that correct?
Correct.
What types of things were in your vehicle that have value?
A whole lot of tools. I have my own painting company. A lot of tools. That speakers in it, 3 speakers, an amp. Lot of miscellaneous tools and speakers.
Okay,
A lot of it.
and you say that's very valuable,
Very
and
expensive.
it sounds like it's essential to your livelihood as well, is that correct? And those are all missing?
Right.
Okay, has any of that ever been recovered that you're aware of?
No,
Okay, and has anyone contacted you with regards to this case?
no.
Okay, now, I told the judge I was gonna bring this up, so I'm gonna bring it up now. Yesterday evening, you were at home, correct?
Correct.
Approximately what time?
Around midnight.
Okay, and what happened around midnight last
Heard
night?
my dog bark at the door. Get out, look outside. I see
Check to relevance, Your Honor.
Did you want to respond to the judge?
Your Honor, I would say it's still relevant because it does appear that there is some sort of, like I said earlier, some sort of violation of a no contact order, at least being attempted on someone's behalf, maybe not at their behalf. Like I said, I could not listen to all the jail calls, but it does, I think it goes to show what is going on in this case and potential intimidation.
Your Honor, my understanding is there's been a no bond for my client for close to 2 months now. There's nothing linking my client to anything that would have happened within the last 24 hours outside Lincoln County Jail. Some random person did something that they're now trying to say my client is responsible for. I don't know how she can make that factual leap to now put that on my client when there's nothing.
She didn't say
that's-
your client, I don't think. Did she say your?
Well, she did before, and that's where she's going. So,
Oh, okay, she didn't say it to me.
No, and after talking to Mr. Lovett, that's not my indication to the court. It's just that it's ongoing issue with the vehicle that was stolen. That's, we're alleging that they stole.
Okay, she never said who had an alleged violation. Maybe she had that conversation with you privately. That didn't happen here in the court. There is a no contact order, whether there was a bond or not, there's still a no contact order. So if, I'm not sure what testimony he's gonna provide, but is it about the vehicle?
It is about the vehicle.
Okay, well, I'll allow it.
Thank you. You said you looked outside. Did you see anything outside?
Yes, I saw, pallet backing up, the reverse lights, and 3 people running into the car,
Okay, and
Check it out.
where was that vehicle parked?
Right.
Or,
right in front of my house, like
okay,
a little bit down, right in the corner.
okay. But you were able to tell that it was an Impala and it had reverse lights on and people entered that vehicle, is
Yeah,
that correct?
they ran into the car
Okay, and where was your vehicle parked?
in my driveway.
Okay, and were you able to get a look at any of those people?
No.
Okay. Did you exit your home to look at your vehicle?
Correct.
What happened when you went outside to do
There's a
that?
broken bent knife right outside.
Okay, and was it inside of your tire or just next to the tire?
Next to it. Obviously broke. Trying to slash it.
So it was broken?
Yeah.
Okay, and it looked to you like someone had tried to slash your tires, is that
Correct.
correct? Okay, and it's your belief that these 2 different acts were done to intimidate you to not be.
Objection.
Correct?
Speculation.
Objection is for speculation.
Yes.
I think, Your Honor, it goes to his state of mind and how he's here today and that he feels intimidated, even if I can't directly link it to either one of these individuals right now. He does feel that way.
Okay, you can ask him how he feels.
Okay, that's fine.
I'll sustain the objection, but I'm sustaining the objection because the question is leading.
Fair, thank you. Did you, how did you feel when your vehicle reappeared at your house?
That it was intimidation.
Okay, and what made you feel that way?
They showed up a day or 2 before the court date. It was either a bribe to not show up, or they still got people out here. That's why the truck's here. So if you do show up, we're gonna come get you.
They know where you live, correct?
Mhm.
Okay, and
Yes.
Correct.
thank you. And with regards to the knife that was found next to your tire, how did that make you feel?
It made me feel like I didn't want to go to court.
Did you feel intimidated?
Correct. Yes.
Scared a little bit to be here today?
Yeah.
Okay. Here. And are you still concerned because people obviously know where you live, correct?
Yes, I am.
Your Honor, I have no further questions for Mr. Levis at this time.
Thank you. Cross-examination.
Thank you, Your Honor. Just a couple of quick follow-up questions. I think that Mr. Jamal actually asked most of what I wanted to ask you on cross, but you had stated that you knew KJ for 1 to 2 years. Is that correct? The individual knew KJ about a year. Okay, that individual had been to your house, you said once a week for about a year?
At least.
At least, so more than once a week? You had never met Mr. Jones except through KJ, is that correct? And you had met him much more recent as of the time of this? A month or 2?
Correct.
And when you were talking to Mr. Jamal earlier, you had said, I believe, about once a week for a month or 2, you had met Mr. Jones at the house, correct?
Correct.
Always with Mr. KJ.
Correct.
So you linked Mr. KJ and Mr. Jones together in your head, is that correct?
Correct.
Aside from that, Mr. Jones has never been at your house alone, is that correct?
Correct.
When I say alone, I mean alone with you.
Yep. Correct.
And the individual you identified as Mr. Jones, the person that put the gun in your face, that person had a mask on as well?
Correct.
And was that mask above or below the nose?
Well, the nose, it was all pretty much exactly the same.
Same kind.
The same mask, and no clothes were the same. You know, the same stuff.
Same type of mask. Is that what you're saying?
Like
Okay.
a medical mask?
No, it wasn't. It was a black mask.
You're saying it was the same hat style?
Yes.
Okay.
Medical mask. I'm saying not a medical mask. Just
Like the ski mask.
So
that you
like,
described.
so like one of those black, they're almost kind of silky in nature, head covering
it's
mask
not
things.
silky, but it's black.
Like a ski mask, but not a fuzzy ski mask like the,
It's like cloth, not silky. I don't know how else to explain it.
stretchy.
Nah, I've never gone to your head. and-
Your Honor, I'm gonna object
Stretch
only
it.
because it's not being alleged that Mr. Levis wore this.
Yeah.
Yeah, he's described it in excruciating detail to Mr. Tomal. He said they're both known to him to wear the same mask, same head covering. I don't think it makes a difference whether it's linen
Okay,
or
yeah.
stretchy,
I'm
but
trying to figure out the kind of mask, Your Honor. I'll move on.
Yeah, I don't think the material is relevant.
thank you.
Thank you.
So just so we're clear, it's that one piece black hat mask combo thing.
Right.
Okay. That's a pretty common mask though, is it not?
I've never seen anybody else wear it.
Were you in the hallway earlier today?
Yes, I would.
Was there a kid walking around wearing one of those masks?
I wouldn't pay attention if you did.
Just following up on the comment that he said he had never seen anybody, and I,
Well, you're talking about a
What hat?
mask and he's talking about a hat and it's 80-something degrees today.
I said I haven't. I didn't say you haven't seen it. I said I haven't seen
that's why I was asking.
He's not talking about a mask, he's talking about a hat that pulls
It's-
over like a mask. That's my understanding of what he described, correct?
That's what I'm trying to figure out what he's talking about.
Mr. Adam, my understanding in Mr. Levis, if you raise your hand or something if I'm wrong, it sounds like this hat is separate from the mask. Is that
Yes.
correct? Okay.
It's like
It's not like a
goes
regular
under the
ski
chin.
mask.
It goes under the chin. not-
Okay. It's not like a normal ski mask that you'd wear to go skiing, correct? And it's not like an open face mask where it's just around. I mean, it is an open face mask and they can wear like a whatever mask over it,
Yes,
correct? Okay.
correct.
It's not one of these kind. Can you see that?
No.
Okay, that's what I thought he was describing. That's why I was trying to figure out what he meant. Okay, for the record, I was showing him a ski mask combo thing, because that's kind of what the corporate was.
Okay.
So I was trying to make sure I didn't understand. So it's two separate pieces.
Yes.
There's a mask, and then there's a hat that comes around the head.
Yes.
Thank you.
Okay, well,
Now we're all on the same
Now I
page.
need
Now-
some clarification. Is it connected though? Or is it two separate
That's
pieces?
why I'm confused.
Okay, sounds good.
The hat covers my client's hair, or the individual you claim to be my client. Is that correct?
Right.
Was your house open or closed?
The door's unlocked. I don't. I'm not.
One of the questions the prosecutor asked you is that nobody had contacted you to tell you they'd given permission to use their vehicle, the other vehicle. Is that correct?
Correct.
Nobody had contacted you to tell you the opposite of that either. Is that correct?
Correct.
You said your dog did not bark. Is that correct?
That's correct.
When you, and I'm going to use the word very legally, speculate that that's because the dog may have known them, is what you testified to, I believe, earlier.
Correct.
But you don't know if that's the case. You just think that.
Correct. I can't talk to my dog.
Thank you. And that's where I was going. I don't have any further questions, Aaron. Thank you.
Mr. Jamal.
Mr. Levis, you indicated that this incident happened on February 13, 2022.
Correct.
Roughly.
Yeah.
Early morning hours.
Correct. I mean, I don't remember it. Or what did you say?
It was in the early morning hours.
What do you call it? Morning, early morning hours? Like early morning. to me
12:30
is
in the
like
morning.
6 in the morning. Huh?
12:30 in the morning at night.
Is at night to me, is what I would say. Like I said, 6 in the morning to me is 6 in the morning. Everything else is.
Morning
night.
starts from 12 at
I get
midnight.
it. That's what I said.
So roughly 12.
Roughly.
And you indicated on direct examination that your Chevy Suburban was recovered in April, meaning it was dropped off at your house.
Correct.
When your Chevy Suburban was dropped off, did you call the police and let them know I got my vehicle back?
I called prosecutor. Sir, I called her. That's the only number I had. And then just the other day, I tried calling another number, but too much of a voicemail, another number, that was too voicemail. I left messages on all of them.
Since April, when you got your vehicle back, did the police ever contact you about taking your vehicle in for evidence?
No.
As far as you know, have the police ever did swabs on your vehicle for DNA?
No.
As far as you know, have the police ever dusted your vehicle for prints?
No.
As far as you know, have the police ever swabbed your keys for DNA?
Nope.
As far as you know, have the police ever dusted your keys for prints?
No, but I still got them if they want to.
Would you be willing to turn them over if they choose to do that?
Yeah.
Now, you indicated on direct examination, you knew KJ for about a year, correct?
Correct.
Did he live in the area, reside in the area?
He did for a while.
Okay, do you know the address he resided at that point in time?
I don't know the numbers on it. I'm on the street.
What street?
Comfort.
You know approximately when he started to come over for a year straight? When did that start, roughly?
Roughly when was the year straight? Year,
When did he start coming over? Do you know approximate date or month?
it was in the summer,
Summer of what year?
a year ago.
21?
Sure.
And that ended when?
They robbed him.
Why was he visiting you?
Excuse me?
Why was KJ visiting you?
Visiting me
Yes.
before the robbery or on the robbery?
Your Honor, I'm gonna
Before-
object at this point. I don't know why. I mean, I'm gonna object on irrelevancy. I don't think it matters why he was
It's
there
relevant.
previously.
No, what's the relevance?
I'm getting into that he has an open door policy. My guy can come in anytime he wants.
I never had that open door
Oh.
policy walk into my
Well, you can
house.
ask, there's an objection, you gotta let me, give a ruling,
I'm
sir.
sorry. I'm sorry.
Yeah, you can ask that question, but you ask, why was he coming over? That's not relevant.
That's fine.
Thank you.
You indicate that KJ would come over. It's either 1 to 3 times a week, 2 to 3 times a week. Is that correct?
Correct.
All right. When KJ would come over during this year period, what door would he enter in your house?
You come in the same door that I came into when he robbed me.
What door?
Side door.
Is that
Dining room
considered,
door.
considered the kitchen door?
Dining room door.
That dining room door, do you typically have that unlocked?
No, I don't.
During the year that KJ would visit you, was that door commonly unlocked or locked?
Locked.
All right. So when KJ would come over, you're saying you have to knock on the door and you let him in
Correct.
every time?
Correct.
Sir, do you go by a nickname,
Tony.
Tony? Okay. You go by a nickname, Tone?
Tony. Kind of all the same thing. I would call that a nickname. It's all Tony. Tony.
Person you indicated that you thought was KJ in your house, that person never threatened your dog, correct?
Nope.
That person never threatened you personally, correct?
Nope.
Did that person ever point a gun at you?
Nope.
Did that person ever say anything to you?
Nope.
Nothing further.
Let me redirect.
Just want to clarify something.
Right.
That everyone's focusing on these masks because you can't see all of their face, okay? But you've known them for 6 months and a year at this point, right? You recognize their voices too, correct?
Correct.
And they both did say something while in your home, correct?
Objection, he just testified, my client said 0.
He
To
said
me.
No,
that
I'm sorry, I get to rule on objections, and ask questions. He definitely said during his direct.
I
that
can hear
his-
you, sir.
He definitely said during his direct that your client spoke to him and said, hey, I got his keys.
Okay, I'll withdraw it.
Thank you.
they both did say something in your home, and you recognize those voices to be the voices that you associate with KJ and Mr. Jones. Is that correct?
Correct. No confusion.
Okay. Further questions?
May this witness be excused?
Yes, Your Honor.
Thank you. Do you have any other witnesses today?
I do not, Your Honor.
Okay.
I do have a certified conviction that I would like to present to court for Mr. Nishan Jackson.
So I'm assuming you're requesting to add a count, is that what's gonna happen?
Correct.
Okay, you may proceed.
Your Honor, this has been marked as people's, or plaintiff's exhibit number 1, for people's exhibit number 1. I'd ask that be entered as a certified conviction. I've already shown it to Mr. Tomal. And yes, I will be using that to add a felon possession charge to Mr. Jackson.
Okay, the People's Exhibit 1 does appear to have a sale as a certified copy of a judgment of sentence. There's no objection to that, Mr. Jamal.
No.
Okay, that will be admitted. And you have any other proofs?
No.
Okay, thank you. Any proofs from the defense?
Not today, Your Honor.
None.
You can proceed to argue.
Your Honor, I'm gonna address count 3 on each. Sorry, I can't read today. This count 3 is with regards to the Buick Encore. We didn't get into any real testimony with regards to the Buick Encore because it's not Mr. Levis's vehicle, and anything that he would be able to testify as to whether there was permission or not would be hearsay. So I'm not gonna go forward on either of those counts at this time. However, the other 3 counts and the 4th count for Mr. Jackson, I would ask that be bound over today. It's clear, based on the testimony of Mr. Lavas, that he was sitting at home when there was 4 men who entered his house, all armed with guns, at which point Mr. Jones directly approached him, pointed a gun directly at his head. So what you got? And he went, patted him down, tried to see if there's anything in his pocket. At that point, he was very scared of what was going on. Also, none of these people had permission to enter into his home. There is testimony from Mr. Lavas that Mr. Jackson is the one who took keys that were present on a bowl in his kitchen, what was directly next to the door that they entered through the house, and said something to the effect of, "I got his keys, let's go." And at that point, he did indicate to the court that he did hear that they did exit the residence. He did hear his car being taken from his home, and he did in fact turn around and go outside or at some point and discover that his vehicle, the Chevy Suburban, was missing. He had not given anyone permission to take his vehicle, to drive his vehicle. Again, he did not give anyone permission to enter his home at this time, did not give anyone permission to steal the keys that belonged to him at this time. And I would argue that even though maybe one was more culpable in the actual stealing of than the other, they were all there to essentially do the same thing. It's clear based on the fact they all come in together. Their faces are primarily covered, even though luckily for him, he's able to recognize their voices, and he gave distinct characteristics of Mr. Jackson's eyes, which is interesting to me, but because he knows that. He can see them, he can see them through them, like he knows what they look like, he recognizes him, he also recognizes his voice. All right, so I think that all of the elements for each count, the armed robbery, the home invasion, first degree, the motor vehicle unlawful driving away, have been met. In addition, for Mr. Jackson, he is a felon. He is not allowed to be in possession of a handgun. Mr. Lovis could not give a specific description of the handgun other than it was a black handgun, but he could recognize it to be a handgun. He didn't think it was real, and it was essentially used to intimidate him, or at least that's how he felt when he recognized all these people in the house with those weapons. So at this time, Your Honor, I ask that Mr. Jones be bound over on counts 1, 2, and 4. And Mr. Jackson be bound over on counts 1, 2, and 4, and an added count 5 as well.
Thank you.
Thank you.
Your Honor, I understand it's a preliminary exam and the burden is probable cause. There's a couple of things that concern me here, Your Honor, and I appreciate for dismissing the 1 count. The issue I ran into, and it kind of got exaggerated a little bit on redirect of the witness by the prosecution, was the timeline of knowing Mr. Jones. And the timeline of knowing Mr. Jones, when I asked him directly, it was 1 or 2 months, maybe once a week, and always with the co-defendant, that he associated the 2 of them together. That he had known the co-defendant for quite some time, at least a year, multiple times a week, maybe 2, maybe 1, maybe 3 times a week, but he associated the 2 of them together. And as a result, these masked individuals come into the house. He claims that was my client, but we heard no evidence that he did some sort of voice lineup where he listened to their voices with them and other people. Nothing like that was presented, simply that I recognize their voices. I understand what the burden is here today, and I'll leave it in the court's discretion, but I have grave concerns regarding this identification of my client as being one of these perpetrators here. And I would like to address the court once we are finished in regards to bond. Thank you, Your Honor.
Sure, I leave mine over to court's best discretion. I'd like to address bond as well.
Thank you. Today was the date that was set for preliminary examination, as indicated by Mr. Cornish. The burden is that on the prosecutor, she has to establish that there's sufficient probable cause that a crime was committed and probable cause sufficient to charge each of the defendants with crimes that were alleged here. We have testimony today of Mr. Anthony Levis, who was the only alleged victim present today. And again, the testimony and evidence that's submitted today does not need to be enough to prove your guilt beyond a reasonable doubt, just more than mere suspicion that a crime was committed. Mr. Levis testified that on February 13, 2022, at the area of 1022 Hateman Street, which is in the city of Lansing, Ingham County, state of Michigan, making venue in this court appropriate. He was sitting on his couch in his living room at about 12:30 in the morning or midnight or however you view time. And when he said the defendants or individuals that he ID'd as the defendants, along with two other individuals, entered into his house through the dining room door. He identified one as a Jovan entering first, and that individual that he knows as KJ entering as well, that he believed himself to be friends with them, that they had been at his house for almost a weekly basis. That Jovan put a gun to his head, patted him down, and said for him to give him what he got, whatever he had. He said that he laughed at Jovan, which upset him, and he threatened to kill his dog. That KJ, or the person he identified as KJ, came and said, I got his keys, at which point they told him not to move, and then he left. They left the property. He said he had a black Suburban and that someone had paid to store another vehicle at the house, and both those vehicles were removed. He also indicated during the testimony that he has a pit bull, and this pit bull barks typically when there are strangers in this property, but at this point, the pit bull did not bark. And so Mr. Cornish is making an argument that he does not believe that there's sufficient evidence to attach his client to the crime, that the testimony was that, at least on redirect, was that the victim, Mr. Levis, associates Mr. Jones with Mr. Jackson. But he did testify that he saw them, that he entered first, put a gun to his head, and although he was wearing a mask, he was able to identify him. I think it's interesting because for the last couple of years, we've all been wearing masks. And we've still been able to identify people. I've been in supermarkets with a mask on, thinking people won't know me while I'm, got my sweats on, trying to run in real quickly. And I see people that I have not seen over a year who say, hi, Judge Simmons. They are able to recognize me. So that's clear indication to me that you can identify somebody that you don't even see regularly, or someone you haven't seen for a long time, who may not even be dressed the way they usually are dressed, with them wearing a mask. I'm also someone who changes my hair all the time, so I thought that would maybe throw someone off if I'm wearing a mask. It doesn't. They still can recognize me by my eyes. But this is someone who testified that has been to his house almost on a weekly basis for at least a month or two. He testified that he recognizes his voice. And then, at least as it relates to a defendant that he identified as KJ, he said that the mask was below his nose, similar to how it is in court today, below his nose. And so if you see someone's eyes and nose, it makes it even more clear who they might be to you. So I think that there is sufficient identification as it relates to that. As to armed robbery, which is count one, well, let's take count two first, which is home invasion. The Michigan Model Criminal Jury Instructions required at the time of trial that the defendant was charged with home invasion first degree. The prosecution must prove first that the defendant broke into a dwelling. It doesn't matter whether anything was actually broken. However, some force must have been used in opening a door. Whether it was locked or not would be sufficient, or would be an example of a break. That they entered a dwelling, though an already open door or window, without using force does not count a break. But again, the testimony was that the door was closed. Second, that the defendant entered the dwelling, and it doesn't matter whether the defendant got his entire body inside. This is the testimony that both entered. So we have sufficient probable cause on that. And third, that the defendant broke and entered the dwelling and he intended to commit a crime, in this case of armed robbery, and that the defendant entered, was present in or leaving the dwelling when he or she committed the alleged offense of armed robbery. We have testimony that parties were both armed, and that they took keys and left vehicles that they had no permission to operate or take. And fourth, that the defendant entered, was present in, or was leaving the dwelling either of the following circumstances existed: A, that he or she was armed with a dangerous weapon, and or another person was lawfully present in the dwelling. Well, Mr. Lovis says he was lawfully present in his own house at the time that they entered, and that they did have a weapon. So I think the court has sufficient probable cause to bind over as to count two, home invasion for Mr. Jovan Jones, or Javon Jones. I'm just trying to see if that's count two on the other file. That is also count two on Mr. Jackson, so that will also be bound over to the circuit court. As to count one on robbery, again, the testimony was that the parties into the home with a firearm or pistol. He was unable to determine what kind of firearm it was, but that he did not identify firearm, and that Mr. Jones was the one who pointed the firearm in his head, that he was patted down, told to give whatever he had of value over to them, that they didn't have and didn't give anything over, and that he likely didn't have anything, but that Mr. Jackson took his car keys along with some other car keys, and they took a vehicle. So the court is satisfied that there's sufficient probable cause to bind over as to count one on both defendants of armed robbery. And the people are moving to dismiss count three, motor vehicle unlawful driving away, because there is insufficient evidence as to whether or not they had authority, or there was authority or permission to drive away. If you would on for had question here, count four, motor vehicle unlawful driving away as to Anthony Lovis's vehicle, the Chevrolet Suburban. The court is satisfied that there's sufficient probable cause to bind over on count four for both defendants. There is a People's Exhibit 1, which was a judgment of sentence for Mr. Rashawn James Jackson, signed by Judge Joyce Dragonchuk. A conviction from May 2nd, 2018. And so the people are seeking to add a count of felon in possession for Mr. Jackson. The court will grant the request and add a count 5 of felon in possession for Mr. Jackson, and that matter will be bound over to the circuit court. Bind over for both files will be May 25th. You will not be arraigned in circuit court unless your attorneys make a motion to the circuit court as to why you need to have a circuit court arraignment. Next court date will be a pretrial in the circuit court, and your attorneys will be made aware of that. I recognize there is a request by both attorneys to address bond.
Thank you, Your Honor. Your Honor, my understanding is that the court denied bond in this matter under 6.106. And certainly that's within the court's discretion, but I guess I caveat and point out to the court that under subparagraph B3, after 90 days, the court is required to set some type of bond. And certainly based on the allegations, we're not asking for a personal or cognizant bond, but I would ask the court to consider the fact that it's been around 50 to 60 days now due to the necessitated adjournments from prosecution on this matter, none of which my client asked for, but was understanding that it had to be moved based on witnesses and things of that nature in the court's schedule. So I guess I would ask the court to consider setting some type of bond that would give him an opportunity to make that bond so that he could be released from jail rather than holding him indefinitely on a no bond and having to bring this back up again in a couple months in front of the circuit court judge because of that 90-day. Thank you.
Your Honor, same argument. My client, if he were to get out of jail, he would reside at his mom's house at 208 Shep Street, Lansing, 48112. He's 23. He has 2 prior convictions, which the court's aware of. There's nothing pending. I'm not aware of any issues while he's been at the jail. The speculation about some tire slashing, I would suggest it's not tied to my guy because we have no proof of that. I would ask the court to consider granting some kind of bond other than no bond. They may have full waiver.
A waiver for,
Circuit court.
we don't need it because they don't do them anymore.
Oh,
That's why I indicated
I
unless
couldn't
you,
hear you.
oh yeah, unless you make a motion, there won't be any arraignment at circuit court.
All right.
They stopped doing those about a year ago, maybe more. Did you want to address the bonds?
Yeah, I recognize that the court rules do require that a bond be set in some fashion at a certain point because of in fairness to the defendant. However, I understand that neither attorney seems to be asking for a personal cognizance bond. I ask that your honor set it a high enough bond that would continue to protect the public. Yes, obviously, we have allegations of somebody still continuing to tamper with the vehicle that was stolen from the victim. Obviously, I don't have anything at this point that ties either defendants to that specific tampering or the return of the vehicle. It does appear to be suspicious, though, that it's returned 2 days prior to court hearing, and then there's a knife found that appeared to have been at least used to attempt to slash tire the day before the adjourned preliminary examination. Both defendants in this matter obviously were just found over on life offenses, and based on my calculations of the guidelines, they are both looking at significant prison terms if they're found guilty at trial. The guidelines that I have for Mr. Jones start at 108 months, and the guidelines that I have for Mr. Jackson start at 135 months, and that is with me being as fair to them as possible. So the likelihood of those being low are very, very possible. That's at least 8 years for one and 10 for the other. I think that they still pose a significant risk to the community, or they would pose a significant risk to the community if they were to be able to post bond because of the fact that they moved to a neighbor who had thought they were his friend. If you're willing to do that to somebody that's your friend or thinks that that is your friend, I would argue to the court that is indicative that they would be willing to do this to other people as well. They do not have any other pending cases currently, but as your honor knows, Mr. Jackson already has a prior felony, and it looks like Mr. Jones, while with no felonies, he does have history that includes other larcenies. So this seems to be a pattern for them. Thank you.
Thank you. Again, the arraigning officials position themselves at the time under NCR 6.106 that bond should be denied because there was a considerable risk to the public safety. And I recognize Mr. Cornish and Mr. Jamal's argument that after a certain time frame, the statute requires bond to be set. We've not reached that time frame, so you should probably take that motion up in circuit court, because I'm not granting bond.
Thank you.
Thank you. There's your exhibit. Did you find Mr. Bastian?
Yes, he's here, Your Honor.
Well, he was over an hour and a half late. I saw him.
Yes.
You're in bond as well?
Yes, ma'am.
What are we doing with bond?
Bond's gonna be a waiver and Bastion's gonna be.
Okay, we'll take They can both come in.
I apologize for my comments.
Oh, this point, I don't know, it's 12 days, I don't think we're gonna have 12 days. I don't think you'll be able to get it two pre-trial. Oh, right, well, we have to do it before, by 9.
All right, so next week.
This must be-
our fourth quarter.
Oh, okay.
That
yeah.
is, right?
Sounds like it. We have so many co-defendants. at this point, I can't keep them straight.
I'm not sure I like that spot, but I'll.
You don't have to always take it. You should
Well, there's 4
take
people.
somebody else over there.
Well, we'll see.
You get a chance, you get a rotation over there.
You take seniority. I think that's who,
No, the other guy. Anyway.
I'm sorry, I'll take the five. I didn't finish the form, but I'm trying to put the note in for right now.
Do you know which?
Yeah, I'm looking at it. And then, was she here? Linda? Or Rita?
No, she didn't. I hadn't seen her.
I didn't say anybody wasn't really good at it.
Like I said, she wasn't sure. She for sure. Either way, didn't either.
Yeah, they count on Jackson.
Yes. Yeah. He's feisty.
Who's that over there? Oh, yeah, nice. Okay, I'm sorry, oh, sorry, I didn't finish the forms. Mr. Bond. We're on the record in the matter of the people of the state of Michigan versus Ryan Bond, file number 22-009881 FY. Council appearance.
Good morning, Your Honor. Andrea Lacey appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Bond.
Okay, how are you, Mr. Bond? Today is the date that was set for preliminary examination. What are we doing on this one?
Your Honor, it's my understanding that at this time, both the people and the defendant are going to unconditionally waive the rights to preliminary examination and ask that this matter be bound over the circuit court. Just for the record, Your Honor, Mr. Feigelson and I have talked about making an offer in this case. Unfortunately, because of CCW, I'm unable to do so. I do expect negotiations to proceed in circuit court, and Mr. Bond was very forthcoming with his interactions with the officers. So I think that's going to fare in his favor in the circuit court.
Mr. Feigelson?
You found that is an accurate statement. This morning, we wish to unconditionally our right to free them, and the negotiations will continue in circuit court.
Okay, and Mr. Bond, you understand that you have the right to have a preliminary examination here in the district court? You understand that at the time of examination, you have the right to have the prosecution meet their burden of probable cause. So that means that it's their responsibility to produce sufficient evidence to show that there was probable cause that a crime was committed and probable cause to charge you with the crime. You understand that? You wish to unconditionally waive your right to that exam today?
Yes, ma'am.
Oh, no, you're fine. You were a little reluctant in a yes. So I just wanted to make sure.
Yeah,
You're sure, because you don't, it's your right to waive. So if you don't want to, you don't have to.
I understand.
Okay. And so, are you sure?
Yes,
Did
ma'am.
you need more time to think about it?
I gotta make it to work, so I
I'm
I
not
don't
saying
have a
today,
choice.
if you want more time, we can waive your 21 days and I'll give you more time to think about it.
Yes, ma'am.
You sure?
Yeah.
Okay,
I mean, well, I want
the extra time.
Yes, ma'am.
Okay.
Yes, I would like the
Due
extra
to
time.
the nature and the extent, I mean, this is serious stuff you're dealing with here, so you don't waive rights that you're not sure you want to waive, because the unconditional part, which we're gonna talk about next, means once you waive it, it's gone. So you could waive this right today, get to work and be like, I shouldn't have waived it.
Right.
And so you need to take more time. I'll find good cause to adjourn this matter. You can talk further with your attorney about it, think about what you want to do. If you decide you want to continue with the waiver, Mr. Feigelson can notify her so she doesn't subpoena witnesses. We can get on Zoom
Okay.
one day. And then take care of the waiver then, if that's what you want to do, okay?
Yes, ma'am.
So I'm gonna find good cause to adjourn to give you more time to think. Can I have a meeting next week, May 20th at 8:30? May 20th at 8:30. And again, if you want to have your exam, you come in person. If you decide that you do want to go forward with the waiver, you can come by Zoom, okay?
Yes, ma'am.
Any additional matters for the record?
No, you're right.
Nothing for the people here.
You're all set, thank you.
But I'll be in touch. Thank you, Mr. Brown.
Okay. Oh, we'll give you a notice real quick.
Oh, I'm sorry.
You're fine. You can have a seat. We'll just get you a copy of your notice to appear. Okay, Mr. Bastian. For the record in the matters of the people of the state of Michigan versus. Pronounce your first name for me?
Jay Warren.
Okay, J. Juan Monter Bastian, file numbers 21-01310, 22-00059, 22-01067. Council appearances.
Good morning, Your Honor. Andrea Lacy appearing on behalf of the people.
Good morning, Your Honor. Assistant Public Defender Stephen Feigelson, appearing on behalf of Mr. Bastian.
Today's the date that's set for pre-trial. It's not the time though, but you were set for 8:30 this morning for, I'm sorry, preliminary examinations, not pre-trials. And you have 3 PA 53 contempts. Why were you late?
I woke up a little bit before 8:30, but I had to walk, so. And then I walked to the one on Kalamazoo and not realizing that it was here, so I had to end up walking over here from over there.
Why did you wake up at 8:30 if you had to be at court at 8:30?
I've been working all week.
Me too.
Tired.
Me too. Mr. Feigel's been working all week too. He was here on time, waiting for you. You set an alarm? Yeah, that's why you woke up late then. You got to set alarm for court dates. Court date times are not suggestions. You got to be here on time. You got witnesses that show up waiting for you. Tie up the whole court when you're not here. I'm trying to figure out what the PA 53 violation is.
I think what the issue is, because I was made aware of this from JSG, I think he had thought he had qualified for funding, and I guess the paperwork never got processed through from him to JSG. So they turned it off and
Yeah, like,
It's not in the file.
I don't know, I think the files my pictures on.
Okay, it was GPS tether ordered. That's the issue.
Correct,
You have
ma'am.
GPS tether? Is that a yes?
Yes, ma'am.
So you didn't get it originally? Is that what the concern was?
That was a funding issue. I think he applied for indigent funding, and I think at some point they never got the paperwork for that request. And because he never paid for the bill, they shut off the tether. I think the
Oh.
issue is the paper.
But that's been resolved.
At this point, I believe it has not been resolved yet.
Well, what's the plan on that?
A couple of things. One, Your Honor, I think he's gonna run out to JSP today to take care of the paperwork, but the other issue, Your Honor, is I believe we have entered into a resolution to this case where I believe we'd be asking the court to modify and remove the GPS tether. Obviously, that's at the court's discretion, or decision, I should say. But that's where we're looking to head with this case.
Okay, what was the offer?
Your Honor, the offer is for Mr. Bastian to plead to 2 counts of domestic violence on case number 22-01067 FY. The people would not object to sentencing under MCL 7694A. We would additionally Killebrew to no upfront jail at this time. I did have a very lengthy discussion with the victim in this case yesterday before talking to Mr. Feigelson, and I'm aware of the tether issue. Obviously, I think Mr. Bastian should have to pay for the time that the tether was on. But at this time, there's been no mention to me about him trying to violate the bond conditions. There's been no mention of contact from him to the victim or even a third party with regards to this case. So I would not have an objection to the tether being removed at this time. If Your Honor is inclined to do that, obviously it appears to be a financial issue as opposed to a safety issue. The victim is not afraid of him violating that bond conditions. Again, there's no allegation that he's actually violated anything other than not paying for the tether.
Okay, sounds good. Do you have a plea sheet? And then a right to vote?
I do not have a plea sheet. I will make one right now.
Yes, please. Thank you.
I just sent the police form first.
Yes,
Daniel. Got you?
We're gonna dismiss the PA 53 violation. And you can just go and take care or settle whatever the balance is that you owe, okay, sir? Okay, the offer that was stated was for you to plead to 2 counts of domestic violence on which file again?
Case number 22-01067. That is the date of incident on that case is 4/23/2022.
Okay, that's what you recall your plea offer to be, sir?
Yes, ma'am.
Do you want to accept it?
Yes, ma'am.
Okay, raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under penalty of perjury?
I do.
Okay, thank you. You can put your hand down, sir. I do have an advice of rights and plea information sheet today. It has a signature affixed to the top and today's date on the bottom. That is that your signature there?
Yes, ma'am.
Did you read this document?
Mhm.
Is that a yes?
Yes, ma'am.
Do you understand the rights listed here?
Yes, ma'am.
Do you have any questions about these rights?
No, ma'am.
Okay. You understand that you have the right to proceed to a trial in this matter?
Yes, ma'am.
You have the right to have a jury trial, and at the time of jury trial, you have the right to remain silent and not have silence be used to prove or implicate your guilt. You have the right to be presumed innocent until each element of the charge is proven guilty beyond a reasonable doubt. You have the right to question or cross-examine any of the witnesses that the prosecution intends to call. You have the right to call your own witnesses or present evidence that you believe would prove or further a defense to the charges. You understand that?
Yes, ma'am.
And if you want to plead guilty, you would give up all of those rights there. That's what you want to do?
What, plead guilty?
Yeah, plead guilty, and that means you have to give up those rights.
Yeah, man. Yes, ma'am.
Okay, you sure about that? That's a yes, because she has to write down what you're saying.
Right.
Okay. Okay, is anybody threatening you to get you to waive your rights and plead guilty today?
No, ma'am.
Is anybody promising you anything to get you to waive your rights and plead guilty? Okay, are you pleading guilty because you believe you're guilty?
Yes, ma'am.
Are you currently on probation or parole?
No, ma'am.
You understand that a guilty plea can result in a conviction that you may need to report to your current employer?
Yes, ma'am.
Okay, and you've discussed how that may or may not impact your employment status, correct? Okay, you understand that a guilty plea can result in a conviction that may impact any immigration status you may be seeking. You understand that?
No, I ain't immigrant, so I don't know.
I know you're not an immigrant. I'm not suggesting that you are. I don't know what you are, but what I'm saying is that you could one day say, hey, I want to move to Canada.
Oh, okay, okay.
And then, you understand that a guilty plea can result in a conviction that could impact any immigration status you may seek in the future.
Oh, okay, I get it. So I wouldn't be able to go nowhere.
I can't say that. It just could have an impact.
Right.
Some places, may look at your criminal history first and say, we don't allow people with those criminal histories to
Right.
get immigration status. Or otherwise, you may not even be allowed to visit some places with a conviction. Do you understand that?
Yes, ma'am.
You're okay with waiving your rights as it relates to that?
Yes, ma'am.
Okay. And there's no objection to sentencing under 769.4A. That's not an agreement that you'll get that. We have to see if you're eligible for that, but there is a Killebrew agreement, which is a sentencing agreement that you will not serve any further upfront jail. And so that's an agreement between you and the prosecutor. I'm not a party to that agreement. If at the time of sentencing, I decide that I'm going to send you to jail, I will give you your opportunity then to decide to withdraw your plea, okay?
Okay.
Okay, so do you have any questions at this time?
No, ma'am.
Okay, as to count 2 of domestic violence, how do you plead?
Guilty.
And as to added count 3 of domestic violence, how do you plead?
Guilty.
Okay. Have a factual basis.
Sure. Mr. Bashley, I'm gonna turn your attention back to April 23rd of 2022. Were you at 4622 Woodridge Road?
Yeah.
That's here in the city of Lansing,
Mhm.
Ingham County?
You said road or truck?
Right.
Yeah.
City of Lansing, Ingham County, state of Michigan. Is that correct?
Mhm.
Is that a yes?
Yes, sir.
And you were there visiting a Selena Rodriguez, is that correct?
Yes, sir.
And who is Selena Rodriguez to you?
Mother of my children.
Okay. Right, and while you were there, you got into some kind of argument with Miss Rodriguez, is that correct?
Yes, sir.
Who initiated that argument?
Uh, Really, I mean, can't really remember back then.
Okay, there was an argument, and what did you do to further escalate that argument?
I mean,
Did you put Miss Rodriguez in fear that you were going to assault her?
yeah,
What actions did you take to put her in fear that you were going to assault her?
I raised my hand at her.
Besides raising your hand,
Uh,
what else? Well, what steps towards raising your hand did you take that would give her the inclination that you were going to strike her?
gave her a warning, told her to leave me alone.
What was your warning? I mean, what did you say to her specifically?
Said so many things to her. That's some time. What I said to the girl.
Did you say that you were going to hit her?
I can't even remember that, bro. I'm, to be honest, if I said that, I would remember it, but I can't even remember that.
Was there a reason why you don't remember this incident, sir?
Like, it probably never happened.
No, I don't think we can plea at this point.
Yeah, I don't have a sufficient factual basis. So we need to reset these examinations, okay? You don't have to be sorry. You should, if you don't believe it happened, I did ask you if you believe, if you're pleading guilty because you believe you're guilty. But it doesn't sound like you're guilty, sir. And so we can proceed with
Like, cause
that.
when I heard about the charges and stuff, like,
Well, I'm gonna stop you just because I don't want you to say anything that could be used against you.
right,
But we don't have sufficient facts based on what you're stating to get a plea on these charges. So what we would do is let the prosecution continue with their responsibility to bring evidence, okay? I need a,
Your Honor, I don't know if this would help at all, but because he is unable to do the plea, my officers are still here. I do intend to run this victim once the victim has not appeared. I could do so after like a lunch break if you wanted.
well, we have, I think another exam. Is that what's going on? Abbott?
As far as I know, that's not going to be the exam
I
today.
thought there was a change in the plea situation.
Okay, for Mr. Hilborn, we're waiting on a criminal responsibility report, but
Okay, so,
also he has a second outstanding case in which there was a package offer.
okay,
And I don't believe Mr. Abbott has had sufficient time to talk to his client about that. Possibly, maybe he may have this morning, but when I talked to him earlier this morning, he had not talked to him about that.
okay, sounds good. We have a 1 o'clock appointment for the court, getting your pictures. So we'll have to convene after that. That's fine, we can do that. That's good. Off the record.
1 o'clock around.
Yes, please.